Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're talking about appeals from beginning to end. I'll have more in just a moment. In case you can't tell, the coof has got me. I came down with COVID on Monday and have been pretty much under the weather, so I apologize for not getting these videos out, but it has been quite the struggle with this little bug. You wouldn't think something so small you can't see it without a microscope cause so much trouble. Anyway, I'm on the mend, I believe, and I wanted to talk today about particularly appeals and how those appeals are handled. So let's jump right into that. Before I go too far down the road here of telling you about appellate procedure, I should point out that all of the examples here are drawn from Missouri law because I'm a Missouri lawyer and I do most of my appellate work in Missouri. Now, I have done appeals in other states and I have done briefing in federal courts all over the country, but for the most part, my appellate practice has been fairly limited to Missouri. So if you are in a different state, in other words, any of the other 49 states other than Missouri, some of this will be applicable, some of it won't, and you need to talk to a lawyer before you would ever think about doing your own appeal, because appeals are very easy to screw up even for very good lawyers. So appeals actually begin well before you're even out of the trial setting. When you are in trial, you're going to get rulings on different things. The judge is going to make legal rulings about what evidence can be admitted, whether something that is said in some way violates a motion in limine or other things like that. You're going to look for rulings of the trial court that go against you. Now, a lot of times, until you get to the end of the case, you don't know whether it's going to come out in favor of you or against you. So you keep a trial notebook of things that went against you so that if you do lose, you can have a viable appeal. And that's what you normally do. Now, a lot of times you get to an appeal before there is ever a trial. And in that situation, you work from the record on appeal, and we'll talk about that in a little bit. But at trial, the first thing that you do is you figure out what legal rulings went against you. And then, after a trial, the first thing you have to do is you have to file a motion for new trial. And in some cases, you file a motion for what's called JNOV. That's Latin. It stands for Judgment Not Obstante Verdicto. And that means judgment notwithstanding the verdict, meaning no matter what the jury found, the legal rules say that this can't survive. So there's that. There's a number of other post-trial motions that can be made, but the most important motion to make is a motion for a new trial. And in that motion for a new trial, you lay out all the reasons why a particular verdict or a particular ruling went against you and substantially prejudiced you and caused you to have an unfair trial. And that is the purpose of the new trial, to call the attention of the trial court to any errors that it may have made in time for it to fix it so that the appellate court doesn't have to step in and fix it. And although motions for new trial are rarely granted, they are granted sometimes. And a well-drafted motion for new trial is almost a template for an appeal later on. So after the motion for new trial is ruled upon and you don't get a new trial, you then have a viable appeal option. And so the next thing you have to do is you have to file a notice of appeal. Now, a notice of appeal is usually done on a form supplied by whatever appellate court you're going to. And it basically says, I'm appealing this ruling of this trial judge in this court, and these are the reasons why I'm appealing. Now, the notice of appeal is filed, usually, it depends on how soon the verdict is considered to be final. A final judgment is normally 30 days after the court has entered that judgment. So the court has the ability to to change the judgment up to 30 days. And in a motion for new trial, it can take up to 90 days for that to happen. But once it's entered its final judgment, it's still viable for the court to change for 30 days. But once that 30 days is over, you usually have a very short time, usually 10 to 15 days, in which to file a notice of appeal. And the notice of appeal, again, just basically tells the appellate court what ruling you're going after and who you are, who the defendant is, all of the technical things that will get fed into the computer at the appellate court level. Now the fun really begins, because what you have to do is you have to start gathering all of the things you will need to make a record for the appeal. The record usually consists of two things: the legal file, which is the written record of work at the trial court, and the transcript. The transcript is the recorded and transcribed version of everything that took place in front of the judge that was on the record. This is one place where even seasoned attorneys get burned, in that someone will convince them to go back into the judge's chambers without the court reporter and reach some kind of agreement on something, but if you don't have it transcribed, it didn't happen. Once you have a legal file on file, you'll get an opportunity to get the transcript on file. The transcript is going to have to be, since it was taken down in stenography, it has to be transcribed into a written document. Here's an example of one of those written documents, and this is from a bankruptcy court, but the transcript in any court is going to look much the same. And it's going to not only have the names of the parties in the cover page, but it's going to have actual testimony or argument that went on at the trial court level. And this is necessary for the appellate court to see what the court's reasoning was with regard to why the court ruled as it did. Now, sometimes you get thrown out of court before you ever get to a trial. This can happen in two ways. You can be dismissed on a motion to dismiss, or you can lose at summary judgment. If you lose at summary judgment, then usually you will have a transcript of the summary judgment hearing, but it will be fairly short. If you get thrown out on a motion to dismiss, there probably won't be a transcript. If there is, you can certainly include it, but it will again be short, and it will just reflect what went on in front of the court. So when you have a proceeding that is going on the legal file alone, that legal file has to support whatever claims of error you are making. And if it doesn't, you're going to have a hard time at the appellate level, because anything that you did not bring to the trial judge's attention is going to be considered waived at the appellate court level. Because if you didn't bring it up to the judge didn't have any chance to act on your concern. So judges are not going to be, they're not going to suffer having their rulings rebuked by an appellate court if indeed the argument wasn't made to them and they didn't have a chance to act on that argument. Thus, it's important to understand that at an appellate level, the record is what controls. In other words, if it's not in the legal file and it's not in the transcript, then you can talk about it all day long, but if you do, you're probably just going to be wasting words, because if it isn't in there, you're not going to get the benefit of what happened. So how does an experienced appellate person go about writing a brief? Well, the first thing they do is they read the legal file and they read the transcript. And in some cases, transcripts can run to 1,000 pages. So if you're a corporate person and you're looking at a bill from an appellate attorney where he's billed for 14 hours for familiarizing himself with the record, that's not uncommon. In fact, if you get a bill from an appellate lawyer and he says that he reviewed a 1,000-page transcript in anything under 5 or 10 hours, you probably ought to worry about whether or not you're going to have good representation at the appellate court. So after you make yourself familiar with the transcript and the legal file, the next thing you do is you turn to the motion for a new trial in the legal file, and you try to figure out what are the very best arguments on appeal. So you make a list of them. Here's a list of arguments. For example, no evidence. There's no evidence that the court relied upon. They didn't comply with the rules. The other side did not meet their burden. And the judge did not carefully review the order that the defendant submitted and just signed it without looking at it. So these are the kinds of errors that you can look at and determine which of those errors is going to be the strongest. So the next thing you do is you prioritize those errors. And when you prioritize those errors, you make some judgments about what is going to be the most effective way to get relief. As I have said on here several times, evidentiary errors, in other words, the admission of evidence by a trial court, is probably not going to get you a reversal. It can be error, but it probably is not going to get you a reversal because judges have discretion in admitting evidence. And if they admit the evidence, it is very unlikely that an appellate court is going to reverse a judgment on that basis. It does happen, and it happens with some frequency in appellate courts all over the country. But it is much less likely to happen for an evidentiary error than for anything else. So here I've grouped my appellate points under, the best thing that I thought was no evidence, and that they didn't comply with the rules, that they didn't meet their burden, and that the judge didn't carefully review the order. I've made some decisions about that reflect my judgment as to what the best points on appeal are. So the next step is to do some legal research point by point, and one of the first things that we have to look at is the standard of review. The standard of review tells us how an appellate court is going to review the error, and this gets back to prioritizing the points on appeal. For example, like I said, an evidentiary error is going to be viewed as an abuse of discretion. In other words, you are going to have to show that the trial court abused its discretion in admitting the evidence. Well, that's a real tough hurdle because the standard that, at least in Missouri, is used is if reasonable minds could disagree about the propriety of the court's ruling, then it's not an abuse of discretion. So think about that. Is it ever possible for reasonable minds not to disagree about something? Well, only if it is really over the top in terms of an error. So you have to be careful about appealing discretionary rulings in that nature. So once you get the standard of review, then you look at the research that has been done, and a lot of this research will have been done for the motion for new trial, so you can rely on that. But you go back to the computerized systems, Westlaw and Lexis and Justia and several of the other ones that are out there on the internet, and you review for the latest cases that your opponent may have missed, cases that you may have missed in the several months that it took to get this into the appellate process. You look for those cases, and you look very hard because these cases are going to help determine how effective your brief is. One of the things that I always do is I look very carefully for the best cases for the other side. If I'm on the other side of this appeal, what are the best cases I'm going to use to try and defeat this claim? What are the best arguments? And then once I know those cases, I can find ways to distinguish them. And sometimes the distinguishing factors are factual and sometimes they're legal, but if I don't know what they are going to say, I don't want to be caught flat-footed. So the next step, after you've gotten the record and the transcript and you've done your legal research and you've reviewed everything, you now have to write the brief. And briefs always have a structure. Let's talk a little bit about that. The structure of the brief is really fairly simple. The first thing you're going to need to do is tell the court, the appellate court, why it has jurisdiction. And you do that in a jurisdictional statement, and you explain why the trial court had jurisdiction and why this appellate court has jurisdiction. Now, there are some claims, at least in Missouri, that can only go to the state Supreme Court. But anything that doesn't go automatically to the state Supreme Court has to go to one of the appellate courts, the lower appellate courts first. And if it doesn't, it will just be transferred to these lower courts after the Supreme Court looks at it. So rather than earning yourself a rebuke from the Supreme Court, you file it usually with the proper appellate court. The next thing you do is you do a statement of facts. A statement of facts is a recitation of everything that is important on the appellate issues before the court. If this is an appeal from a case that was tried to a jury, and there is transcript that shows what happened in the courtroom, that will need to be referenced, as well as just basically what happened. Now, it oftentimes is a situation where if you don't put enough into the statement of facts, the other side is going to put in all of the things that you left out, and generally those will be the things that hurt you, so it makes it look like you are hiding the ball from the court. If something happened at that trial that goes badly against you, or that does not support your point, it needs to be in the statement of facts anyway, because the statement of facts is supposed to be a fair recitation of what happened at trial without argument. So when you talk about the trial judge admitted the evidence from the expert witness, you write that as the trial judge admitted the evidence from the expert witness with regard to whatever. You don't say the trial judge erroneously admitted that it, because that's argument. You just say he admitted this evidence, and you get into the erroneous later on. So then, even though it's not required in most cases, although it certainly is in federal court briefing, but in state court briefing it's not usually required, to do an introduction to the argument, where basically you lay out in summary fashion the arguments you're going to make and why they're important. And then you go right into the argument portion of the brief. So the argument portion of the brief contains your points on appeal and all of that. And then you go into the conclusion, and the conclusion basically tells the court what you think should happen. It should be reversed and remanded. Or if you are the respondent in the brief, the party that is defending having won at the trial court level, if you're the respondent, you say, the trial court's ruling should not be disturbed. So how is the argument section structured? First of all, you start with a point on appeal, or in Missouri we call it a point relied on. And the point relied on, it's a technical term in Missouri. It requires you to state or identify the trial court ruling or action that the appellant challenges. In other words, what trial court ruling what error did the judge make on a ruling? State concisely the legal reason for the appellant's claim of reversible error. So, for example, the trial court erred in admitting the evidence of the wife of the plaintiff because it was hearsay. And then C, explain in summary fashion why in the context of the case those legal reasons support the claims of reversal or reversible error. And basically what that does is it says, you're going to lay out in very quick fashion why you think the ruling should stand. So here is a point relied on from a brief, and it says, the trial court erred in entering the judgment on dismissal on the basis of forum nonconvenience. Okay, right there is your first part. You identified the order that you're appealing from. It's a dismissal order based on forum nonconvenience. Because the court never received any evidence of actual inconvenience. So there is the legal reason why you're appealing. There is no evidence supporting the trial court's ruling. And then in that, defendant's motion was not verified. A verified motion is essentially attaching an affidavit at the bottom of the pleading saying everything above is true based on my personal knowledge. In this case, the defendant's motion was not verified, was not supported by any affidavits, and the facts pleaded in the petition did not support the court's finding. So you've laid out all of the reasons in the context of the case why this particular thing should cause the order to be reversed and remanded. And then you write the body of the argument. And the body of the argument will track to a certain degree the issues that you've raised on appeal. You'll come up with the issue, the issue that you have identified. In this case, can a court issue an order of dismissal for something that requires evidence without having evidence? Then you will address the rule. And if there's a rule, it will come from case law, and you'll identify the rule and you'll identify the case. Then you do analysis. You say, this is what happened, and this is why it's wrong, and this is why it prejudiced us. We didn't get a fair chance in this because we never got a chance to address the evidence because there was no evidence. So that's how that works. Now, the thing that you have to be aware of is that in every appeal, there is going to be a certain number of words that you are allowed. And the certain number of words that you are allowed is essentially whatever the court in that particular district gives you. In the Western District of Missouri, for example, if you're an appellant, you get 15,500 words to make your opening brief. And then the respondent gets 1,1950 words, and then in any reply brief does not exceed 5,115 words. So as the case progresses forward, the number of words that each party has is significantly reduced because you want to focus your arguments and focus your analysis for the court. And that's pretty much what every appellate attorney does. Now, once you file your appellant's brief, the respondent is going to get 30 days, and usually longer if they ask, to write a respondent's brief. And the respondent's brief is going to attack your brief point by point. This is why they're full of beans on this issue. This is why they're full of beans on the other issue. And they will file their respondent's brief, and then you will have an opportunity to file a reply brief. You only have 30% of the words that you initially started out with, in this case, 5,000. So you have to focus your argument very tightly on the things that you believe their brief is most damaging to you on. And that's what we do. We go and we look at that and we explain why their argument is wrong. They argued this is why that's wrong. And then after the reply brief, all of the briefing is done. The next thing that has to happen is oral argument. An oral argument is something that I think most lawyers enjoy. Being a writer and not necessarily a speaker, I don't necessarily enjoy oral argument, so I over-prepare for it in the event that, I do have to get up and do an oral argument. And the oral argument is basically you get up and you start talking to the appellate court. You're saying, Judge, we believe this case should be reversed and remanded because and within a minute you're going to draw a question. Counsel, what about this? Counsel, what about that? You said in your brief that this, but I don't see any reference to that in the record. Those are the kinds of questions you get from the appellate bench. And usually it will be what we call a hot bench, meaning they will have read your brief, they will have read your respondent's brief, and they'll have read your reply brief. And they will know all of the issues. And this is an opportunity for you to help them come up with the right result. And if you don't do that, then you're probably going to lose. Well, I guess it's been more than a year ago now. I had a case where I had to go do oral argument in St. Louis at the Eastern District Court of Appeals. And it is rare for me to work against an appellate defender that is just over the top with some of their arguments. And some of the arguments that the other side made in that case were just ridiculous. And the one thing that they did very well was they confused the issues very badly. They did such a good job of confusing the issues that one of the judges on the panel was ready to grant the appellants, I was the respondent, grant the appellants their relief that they sought, which was a reversal and a remand. And that was just clearly not appropriate. And I struggled through oral argument trying to explain why it was. And finally, one of the appellate judges said, "Is what you're really saying this?" And he just recited it back to me in a way that was far more coherent than anything that I had done up to that point. And I said, yes, Judge, that's exactly right. And eventually, we did win in that particular case. But oral argument can be pretty scary if you've never done it before. That's one of the reasons why in law schools they make people go through that process several times in order to give them some experience in handling those kinds of questions from an appellate bench. So that's the point up to the point where the appellate court will render its decision. So it depends on how fast the court works. The Eastern District Court of Appeals in Missouri works very fast. The Western District works not quite as fast, but very diligently. And the Southern District, it just varies. The process that the courts use internally is pretty much the same. After oral argument, they all sit down and they decide how the case is going to be decided, either for the appellant or for the respondent. And then it gets assigned to a judge, and a judge writes the first draft of the opinion. And he circulates it to the other judges, and if the other judges agree, they sign on and it becomes the opinion. So if it's a particularly easy case, that's what will happen, and you'll get an opinion fairly quickly, maybe within as short a time as 2 weeks. If it's a particularly difficult case, or there's a lot of acrimony about what the right result should be, or if you have judges that don't work well together, you may wind up with somebody writing a dissent. And if you have somebody writing a dissent or a concurrence, then it can muddy the waters a little bit. And that's never really a good thing, but it will, at the very least, get an opinion out there. Now, once you have the opinion of the court, the next thing you have to do, if you've lost, whether you're respondent or the appellant, is you have to move for reconsideration. You move for reconsideration, or in Missouri, you move for transfer to the Supreme Court. Now, the Supreme Court doesn't take every case that is moved to be transferred to it, and it only gets transferred if it's a matter of great interest and importance, or if there's a disagreement between the Eastern District and the Western District, or between the Western District and the Southern District. If one of the other two courts of appeal have decided cases substantially similar but reached contrary results, a lot of times the Missouri Supreme Court will step in. Now, I don't know how that plays out in other states, but that's how it works in Missouri. If the appellate court doesn't reconsider the opinion, they will deny the request. You then can, and they will deny the request to transfer it to the Supreme Court. And then you will have an opportunity to make an application to the Supreme Court. And if the Supreme Court takes your case, you get to present it all over again at the Supreme Court level. If you don't, if the Supreme Court doesn't take your case, then the appellate court that you went to, whether it's Eastern District or Western District, whichever one it was, they will issue what's called a mandate. And the mandate is an order of the appellate court saying this case is affirmed or this case is reversed and remanded. So that's how the process works. That is appeals from A to Z. Now, I've talked about civil appeals here, not criminal appeals. But criminal appeals are not a whole lot different. The law is quite different on many of the evidentiary issues and on many other things. But the actual process of getting the whole thing to the point where a court can make a decision about whether the trial court erred or not, that is vastly the same even for a criminal case. The one difference is that in addition to having a right of appeal, an appellant, or I should say a criminal defendant who is convicted, has a right to ask for ineffective assistance of counsel claims. Basically, to make claims that the lawyer that represented them was a complete screw-up, didn't do anything he was asked to do, and as a result of that, everything the guy did was just wrong. So they have this in Missouri, it's called a 2915 motion, or if there's a plea, it's sometimes called a 24.035 motion. And these motions are designed to get the trial court to perhaps make a different determination about whether the whole thing was properly done. Now, one thing that Missouri courts do when there is a criminal conviction is they will ask the defendant in open court, do you have anything you want to say about your lawyer? Do you think your lawyer did a good job for you? Did he do a bad job for you? Tell me what you think about your lawyer. And if you want, we'll have him out of the room so that you can speak freely. In most cases, because lawyers don't routinely screw up, they will say, yeah, I think he did an okay job. I don't like the outcome, but yeah, I think he did an okay job. If indeed they don't claim that, then what they're doing is they're laying a foundation for their later ineffective assistance of counsel claim. And surprisingly, sometimes those are quite effective. And that again deals with the quality of the people who are representing them. And I'm not talking about public defenders here. A lot of times private attorneys do bad jobs on criminal cases. And if they do, then appellate assistance of counsel is such that they can get help addressing this ineffective assistance of counsel claim. A couple of years ago in Florida, there was a group of 6 people who got together and murdered a 15-year-old boy. And of those 6 people, there was a 15-year-old girl and an 18-year-old girl who were also convicted of first-degree murder. And the 15-year-old girl did not make an ineffective assistance of counsel claim, but the 18-year-old did. And when that ineffective assistance of counsel claim was evaluated by the Florida courts, it was held to be, this guy did an inadequate job of representing this girl, and as a result, her conviction was reversed. Now, there was no way it was going to stay reversed. She was entitled to a new trial, but the evidence against her was overwhelming, and she had confessed on videotape not just once, but multiple times over the course of several hours. And as a result of that, she knew she was going to get convicted of something. So her lawyer made a deal with the prosecutor where she would plead guilty to second-degree murder, and as a result of that, she would be eligible for parole, and she got out on parole at the age of 27, where the 15-year-old girl is still in prison. So that's the A to Z of appeals and appellate work. Hopefully this has answered your questions. If you have any questions from this video, please feel free to leave them in the comments down below. You know all the things we ask you to do: like, share, subscribe, do whatever you like in that regard. It really helps me, and I thank you for that. Again, I appreciate you watching, and I hope you have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.